Welcome to the presentation of the 7th Annual Justice Prize, honoring courageous individuals who have furthered the cause of justice throughout the world. We're delighted to be here at Georgetown University Law Center for this presentation, a place that has educated so many distinguished attorneys and jurists. I'm pleased to introduce our host here at Georgetown, Alexander Alenikoff, Dean of Georgetown Law Center and Executive Vice President of Georgetown University. Dean Alenikoff has been a member of the Georgetown faculty since 1997, and he has served as its dean since July of 2004. He has written widely on immigration, refugee and citizenship law and policy, constitution law, statutory interpretation, and race discrimination. Ladies and gentlemen, Dean Alenikoff.
Thank you very much, Patricia. And it is my great pleasure to welcome you and the Gruber Foundation staff to Georgetown Law today, and to all the folks who have come to this wonderful ceremony and panel discussion. And I'm particularly delighted to welcome our 3 Justice Prize awardees, Justice Argibay, Judge Cerda, and Ms. Feria, who we'll be hearing from in just a minute. We are so pleased to see you here today. And of course, we are honored by the presence of Justice Ginsburg. As always, we are delighted to see you here at Georgetown. Georgetown Law prides itself on its strong commitment to human rights. And it is our great pleasure to host today's award ceremony and the symposium. Now, the topic of the symposium, Courts at Risk, Rights in Peril, is timely. Unfortunately, in our world, this topic always seems timely. And few are better positioned to discuss this issue and propose a way forward than the incredible jurists and human rights advocates who are with us today. Through your innovative advocacy, your courage, and your determination, you've shown yourselves to be true champions of justice and have shown your willingness to fight when courts are at risk and rights are at peril. And so on behalf of Georgetown Law and our Human Rights Institute, I'd like to extend my deepest congratulations to the 3 Gruber Justice Prize Award winners, to commend them for their inspirational work on behalf of the cause of human rights. And I look forward to what will be a fascinating discussion. Welcome.
Thank you, Dean Alenikoff. We are in the presence of many distinguished guests here today, and we will be hearing from many of them later in today's program. However, there is one we would not be hearing from, and that we are delighted to welcome, and that is Argentine Ambassador Jose Bordon. Ambassador. The Foundation's prize program was established in 2000, and we now present 5 annual $500,000 prizes in the fields of cosmology, genetics, neuroscience, justice, and women's rights. Each prize recognizes achievements and discoveries that produce fundamental shifts in human knowledge and culture. Last month, the Cosmology Prize was presented to Saul Perlmutter and Brian Schmidt and their 2 teams, the Supernova Cosmology Project and the High Z Supernova Search Team. They both independently discovered that the expansion of the universe is accelerating. Next week, Pinar Ilkarakan and the organizations that she co-founded will receive the Women's Rights Prize for helping reform Turkish laws to advance gender equality and human rights in Muslim societies. Later this month, Maynard Olson will receive the Genetics Prize for his founding role in establishing the field of genomics. Early in November, Shigetada Nakanishi will receive the Neuroscience Prize for his pioneering research into the communication between nerve cells. I'd like to acknowledge the founding vision of my husband, Peter Gruber, in establishing these prizes. His spirit of generosity is a guiding force for all of us at this foundation. Unfortunately, he's not feeling well and could not be here with us today. But he sends his warmest congratulations to all of our recipients here today and to all of you for coming to attend today's ceremony. We award the Justice Prize on an annual basis to honor those who advance the cause of justice as delivered through the legal system. Past recipients of this Justice Prize are most recently Aharon Barak, retired President of the Supreme Court of Israel, Dato Param Kumaraswamy, a Malaysian attorney, Chief Justice Arthur Chaskelson, and Deputy Chief Justice Pius Langa from South Africa's Constitutional Court, Fali Sam Nariman, President of the Bar Association of India, and together, Justice Anthony Roy Gubby, former Chief Justice of Zimbabwe and the Law Society of Zimbabwe, who received our first Justice Prize. And now to the presentation of the 2007 prize. As you may know, we are privileged to have a distinguished international board of advisors who serve as a selection committee for each year's laureates. This year, its members are Rosalie Silberman Abella, Dennis Archer, Giuseppe Bisconti, Arthur Chaskelson, Martin Lee, and Sandra Day O'Connor. My husband Peter and I deeply appreciate the knowledge, the commitment, and the enthusiasm that these advisors bring to selecting each justice recipient. We'd like to announce the 2007 recipients of the Justice Prize: Justice Carmen Argibay from Argentina, Judge Carlos Cerda from Chile, and attorney Mónica Feria from Peru. And before I ask the recipients to step
Three of our recipients not only had exceptional careers of their own, but through their numerous and exceptional achievements, they made a difference in bringing justice to the people, both nationally and internationally. That is what we celebrate today, and that is what the Gruber Foundation Justice Prize stands for: excellence. The title of the symposium, which we will follow, cannot be more appropriate here. Where are all the courageous ones? Well, they are there, the courageous one. And I cannot here but underline another courageous one, Justice Ruth Bader Ginsburg, to whom we are very grateful to have accepted while in full session of the court, to which we invited some of us this morning to attend to preside the symposium a little bit later on. On her latest dissent in particular on discrimination against women in the workplace is a lesson of courage in itself, the courage to stand for justice for all. Thank you, Ruth, for this. Most of you probably know by now much about our prize recipients. Let me, however, outline the main features of their journey through law and justice. Not only did Justice Carmen Argibay go to jail for her stand on freedom, justice, and democracy, but all along her most distinguished career as a lawyer and on the bench, she cared about her fellow citizens, particularly the underprivileged ones. For example, she initiated, and for 33 years, every Saturday, she participated in the education of women workers in her country. A human rights activist all along, she was a member of the People's Tribunal on Comfort Women, exposing to the world the cruel treatment of those abused women during World War II. The Yugoslavia War Crime Tribunal, to which she was nominated by her country, provided another opportunity to denounce crimes against humanity. Her nomination as the first woman to the Supreme Court of Argentina does underline the high esteem in which she's held by her peers and the hope for justice for all she brings to her country. And here I must stop from a very last minute message that was received from the Office of Justice Argibay. And the message says, "We find that it is an excellent expression of what the Justice Prize stands for and clearly applies to all three of those honored today." And here it reads, and that's what we got. Dear Dr. Argibay, those of us who have had the distinction of working with you wanted in some way to accompany you on this very special day, the day in which you will be awarded for your valor. Much courage is needed to transform life's painful experiences into something positive for oneself, and even more is needed to do so for others. This is what you have done invariably and what you have taught us by example to do. To fight for your convictions in favor of justice, but essentially to act with those same convictions. We know that distances cannot lessen the enormous affection that we send you in this letter, your colleagues. Interestingly, Judge Carlos Cerda's career as a legal scholar and judge has also brought him to investigate gross human rights abuses during the Pinochet regime. He took a very courageous stand in bringing indictments against members of the Chilean military and their collaborators, for which he paid a very heavy price also. Courage is the mark of great judges, and Judge Cerda's rectitude, courage, honesty, and independence in the pursuit of justice has suscited the admiration not only of his country, but around the world for, and I quote, one of the most brilliant jurists of Chile today. Judge Carlos Cerda's life is seen both in academics and in the judiciary as a testimony to a deep commitment to the values of law. And in this day and age, it is comforting to know that judges like Judge Cerda are guardians of the human condition when threatened by power as he himself said. As a practicing international lawyer, Mónica Feria has worked on issues pertaining to state responsibility for genocide and a commander's responsibility for massacres. A brilliant scholar, in 2000 she was awarded, among others, the diploma of the Hague Academy of International Law, becoming the first Peruvian lawyer ever to have been awarded such a great distinction. Mónica Feria was herself imprisoned, tortured, and survived a massacre by orders of Alberto Fujimori, which prompted her to apply for and was given refugee status in the UK. As an international lawyer, she has championed the fight against torture around the world and argued the first international case concerning the rights of children in times of war, as well as bringing reparation to victims of crimes against humanity, involving thousands of people and crimes of violence against women. For her courage, she paid a heavy price, but the numerous awards she has received are a tribute to her exceptional dedication to justice and human rights. So these are three remarkable persons the Peter and Patricia Gruber Foundation does celebrate today. I would now would like to ask my fellow advisor Giuseppe Visconti to read the official citation honoring our three laureates. Mr. Visconti is past president of the International Bar Association and is currently chair of the International Foundation for the Rule of Law and the Independence of Lawyers and Judges. Giuseppe? No, I can go this way.
President Patricia Gruber, distinguished ladies and gentlemen, it has been a privilege for me to participate as a member of the Board of Advisors in the process of selection of the candidates for and the award of the 2007 Justice Prize of the Peter and Patricia Gruber Foundation. This process of selection is very different from other processes for the award of a prize that I have participated in or that I may know of, which are essentially based on evaluation of the competence, achievements, distinctions, professional, artistic, or otherwise, of the candidates. The process of selection of this prize gives you the opportunity and requires that you read and delve into the life of the candidates, that you understand and feel as if they were your own, the hardships, sacrifices, injustices they have suffered, and the efforts and actions they have undertaken, sometimes at the cost of physical injury or deprivation, or even at the risk of life, well beyond the call of duty, and often truly heroic, in order to defend, assert, and attain justice for themselves, and more significantly for others. These champions of justice have made us understand the deep, profound wound of injustice and the pregnant significance of justice for all human beings. I am grateful to and would like to thank the Peter and Patricia Gruber Foundation, also on behalf of my fellow advisors, who could not be here today, for the privilege they have bestowed on us by allowing us to participate in this process. The 2007 Justice Prize of the Peter and Patricia Gruber Foundation is hereby proudly presented to Carmen Argibay, Carlos José Cerda Fernández, and Mónica Feria, who overcame personal experiences of profound injustice to become outspoken champions of justice. Through their enormous personal courage and tenacious commitment to a just rule of law, they challenged the absence of rights in their respective worlds, and in so doing brought justice to their own countries and inspiration to human rights advocates around the globe. Es un gran honor y un momento de grande felicidad. I'm very honored to ask Justice Carmen Argibay, Judge Carlos José Cerda Fernández, and Attorney Mónica Feria, please come here to receive the prize.
so much. And Mónica Feria Tinta. And Carlos Cerda. Warm congratulations to all three honorees. We will have the opportunity to hear from each of them shortly. But now it is my great pleasure and honor to introduce Justice Ruth Bader Ginsburg, who will serve as the moderator of our symposium titled Courts at Risk, Rights in Peril, Where Have All the Courageous Gone? Justice Ginsburg has been an Associate Justice of the United States Supreme Court since August of 1993. She was nominated to the court by President Bill Clinton, who announced he was looking for a nominee with, quote, a fine mind, good judgment, wide experience in the law and in problems of real people, and somebody with a big heart. Calling Federal Appeals Court Judge Ginsburg the Thurgood Marshall of gender equality law, he concluded that she possessed the requisite intellectual and emotional stature for the job. She has certainly proved him correct. Justice Ginsburg.
Thank you, Patricia Gruber, for inviting me to share this spirit-lifting occasion with you. I first heard about the courageous 2007 Justice Prize winners from my dear friend Claire LaRue Dubé, herself a brave and tireless promoter of human rights throughout the world. To Claire's suggestion that I attend this prize presentation, I answered at once, "Mais oui." In good times, when peace and prosperity prevail, it is easy to champion rights and freedom. The way paved by the jurists we honor today has not been easy. They have held fast to their ideals in the worst of times, times when fear overwhelmed and silenced everyday good people. Our honorees were not among the silent. They have risked their own security in pursuit of justice for others, for people prey to abuse and oppression imposed by dictatorial, inhumane, corrupt regimes. I am in awe of their achievements in the face of adversity, and in common with all gathered here, I draw inspiration from their example. The topic selected to fill the next segment of the program, as you have heard, is Courts at Risk, Rights in Peril. And to open the discussion, I will ask each of our laureates to comment briefly on the endeavors for which we honor them and on the current state of justice in their respective lands. Justice Argibay, may we hear from you first?
Thank you, Justice Ginsburg. And I'm very touched and very moved because I didn't expect this message from my colleagues in Argentina. It took me by surprise. But I must say that this prize also took me by surprise. So I had to thank the Gruber Foundation and Pat Persons here and Peter that's absent. But I'm really, this was very special for me. I've been working for human rights for a long time. I've been working for women's rights, that are human rights, of course, since a long time. I'm one of the founders of the International Association of Women Judges, and I have the pride of saying I was one of the presidents of this magnificent institution. I think this bad experience in prison during the military dictatorship, staying without charges, without trial, without knowing why I was there, except that they didn't like me, evidently, not knowing when I was going out, if I was going to go out. I think that changed my life in some aspects. I think I just, at that moment, I just was conscious that when you are to the bottom of your life, you have nothing in the sense of social paintings or something, just you are reduced to your own real, pure self, then you know if you're a good person or not. And I think I discovered I was fairly good, a fairly good person. Because what I wanted to do was to help. And I remember those 9 months in prison, 9 months, nearly a pregnancy, teaching to my fellow prisoners English and French, and starting every day again and again, because when the guards were coming in, they were destroying whatever they couldn't understand, of course, and that were our notes in English and in French, and it was started again and again to try to do something. And on Friday nights, I had instituted we are going to the cinema, and as I had a very good memory and I was a very good reader and I had to read a lot about literature, I started relating, for instance, The Count of Monte Cristo as if it were a film or something. So we went to the cinema on Friday, And that made things a little bit easy. And that shows that I'm a survivor. And I found out that I was a survivor. And I think that is what brought me the Justice Prize here, because I hope the day I put my foot out of prison and say, this thing must not happen anymore, no more in my country. Nunca más. That's the end of the trials of the juntas. That's the end of the CONADEP investigation of the crimes against humanity, the desaparecidos in Argentina. That's the word for us. Never more we want to have this sort of dictatorship in my country. Never more. So I'm here through the rule of law, just affirming the rule of law and justice, to see that never more a dictatorship would come to my country. Thank you very much.
We'll hear next from Judge Cerda.
President Patricia Gruber, Justice Ginsburg, member of the jury, ladies and gentlemen. With delight, I have come here today to receive this award. With pride, I accept it, as it represents the part of our humanity that should matter the most to us, the dignity of the people. And with hope, I project it towards a future in which the duty of a judge is understood and assumed to be, in essence, committed to the living source of the law. I am being honored, from one part, because of my behavior as a judge during a period of the history of the Republic of Chile in which the fundamental rights of the people were not recognized. I am being honored also because of my contribution as law professor and a scholar in the Judicial Academy, and in the daily practice of encouragement and strengthening of a juridical culture of principles, which is in line with the main purpose of the Justice Prize, to encourage further advancements in the field and progress toward bringing about fundamentally just work. In an early thesis with which I complete a special scientific doctorate at the Catholic University of Leuven, Belgium, entitled The Judge and the Judicial Values, I believe I found sufficient scientific basis to conclude that the law itself is not autonomous, the law as a rule of law, is not autonomous from other factors present in the decisions of justice, such as the circumstances of the concrete case, the social reality in which this case takes place, the scope and significance of the language in which it is expressed, the pertinent norm, the functionality of the system of which this norm is part, principles that inspire and inform the legal system, current cultural reference, and pertinent historical ethics. Such a theory generates an immediate reaction. Where is left then the legal certainty? Where is the predictability of the judicial decisions? At that time, I felt compelled to study further these essential issues, and the University of Paris II French give me the opportunity to undertake a doctorat de troisième cycle, where my thesis, The Nature of the Process of Law, looked for establishing the basis of the relevance of the process of law as a means of rooting into society principles and values of law. The 80s arrived. Chilean law lives through exceptional times. The judiciary tolerates what today we know were flagrant violations of human rights. I assume a jurisdictional behavior consequent with my understanding of being a judge, producing resolutions seen by my superiors in a hostile light, and resulting in sanctions that nearly resulted in my removal from the judiciary. I had not been able to convince my superiors, nor most of my colleagues at the court, of the justification for my resolutions. A new challenge knew then how to establish the legitimacy of the decision of justice. In other words, how to ensure this is appreciated as just. Harvard Law School had the keenness and patience to receive this sort of beggar of the just cause, who as a visiting scholar in 87-88 investigate the complex process that supports judicial decision-making. What, who, and how is the judge in the process of elaboration of the decision? Is there a place in this process for the way of being, psychis, of an understanding logos of the judge? If so, at what point is this not a dangerous subjectivism? Where might democracies drift in the face of a government of judges? Is it possible to discard personality or internality from the judicial decision? Should this be a goal in any case? Once again, where would this leave legal certainty? What is and what rests such certainty, and so forth? I advocate that the justification seeking to legitimate the decision includes the underlying motivations that have guided the judge in favor of the one the judge values at the best, among several possible right answers. Nevertheless, this, my view, is not everly accepted. I come here today feeling that emptiness. Destiny allowed me to pursue a path that I find fulfilling, both vocationally and professionally. Far from being a sacrifice, this has been a gift. What better gift than feeling oneself a judge of the people? I am conscious that I have lived in times in which doing the right thing has been seen as heroic. From my humble point of view, in my case, it has not been heroism, at least from an individual point of view. I could certainly say a different thing about those who surround me, my wife, and our 7 children, who, with good reason, have wanted more from their husband and father. The strength that moves me has provided me with clarity in my mission. I do not remember fearing. I hope I have done what in which I have believed, in peace, without hate, far away from vanity and selfishness, in conscience. Thank you, Mrs. Gruber and Mr. Gruber, by the way of you. Thank you, those who work at the Gruber Foundation. Thank you to everyone present today, especially to Carmen and Mónica, who today make me feel as special as they are, which is saying something. Thank you, Adriana, Juan Pablo, Adrianita, Francisca, Carlos José, Cristóbal, Martita y Bernardita. Thank you, all members of the jury, for showing the world this style of being a judge that, with all humility, can serve to those who intend doing justice among human rights. Thank you.
And finally, Mónica Feria, may we hear from you?
Thank you, Justice Ginsburg, and thank you to you all for being here today. Patricia Gruber, thank you so much for the honor that the foundation makes me to allow me to be today among you and talk a little bit about the situation in my country and share with you some thoughts. My experience comes from 1992, and I consider that I really lived through a schooling of law. I think that Judge Argibay made very important remarks about how sometimes lawyers were confronted with life where violations occurred, and actually we are there together with the people that are suffering these violations. This provokes such a, I would say, touched me in such a way that certainly changed my mentality and deeply pointed at the direction where I wanted to head. It's been said today that about the healing power of justice. I think it's so true. Justice heals. And my input as an advocate, as a lawyer, as an attorney, was to help shaping the law in the direction to make impunity something of the past in our days, and use law in a way that we could redress violations and we could redress the authoritarian use of power against individuals. My work concentrated in three areas. I believe on the area of prisoners' rights, on the area of women's rights, because I, perhaps because of my own condition as a woman, brought together a gender perspective in my own pleadings in the cases where I work. And finally, I wanted, obviously, to have legal consequences from actions that have caused great suffering to individuals and constituted crimes. For me, we share something in common with my co-recipients. We have a clear, perhaps, attitude towards the need to deal with impunity in the Latin American region. And I believe that that's a contribution towards the world, because we are living new days. Grotius, an international lawyer from the last century, used to say that the ultimate source of law is human consciousness. I believe that's very true. I believe that law is what we actually made of it as human beings, and how we digest our own experiences of applying it to our realities. So I can only, I'm open to questions. I know you are maybe interested in many different aspects of what's been going on in our respective countries, including Peru. We have had news of the recent extradition of Alberto Fujimori. It's the first time that a former head of a state is extradited to a stand trial for crimes against humanity. And this is what is happening now in Peru. We look forward that justice will be done, that due process will be respected, not just from the perspective of the accused person, but as the Inter-American Court of Human Rights has pointed out, also from the perspective of the victims, because due process has to do with the determination of the rights not only of the accused person, but also of the victim that has suffered the legal injury. So, well, I leave the floor to Justice Ginsburg. Thank you so much for your attention, and thank you for being with us today.
I have a set of questions that was suggested by the Peter and Patricia Gruber Foundation, and after that, we will enlarge the discussion to incorporate your questions. So my first set of questions are for Justice Argibay. And the question comes in three parts with an introduction. The introduction is that in the 1980s and 1990s, members of the military who allegedly committed gross violations of human rights were accorded what Monica just referred to as impunity from prosecution and other liability. That situation has changed, and now there are three questions. First, what actions did the different organs of government, the president, the legislature, and the judiciary, take to withdraw that immunity from the military officers? And second, have any prosecutions in fact been instituted against the alleged human rights violators? And finally, did international human rights figure in the withdrawal of impunity from those human rights violators? So if you can start with what role did international human rights have in promoting the change that occurred, in promoting the withdrawal of the immunity?
Mm-hmm. Okay. Yeah, thank you, Justice Ginsburg. I'll try to be short, but try to be clear. After the democracy sets in 1983, at the end of 1983, there was a resolution by the government, the democratic government of President Alfonsín, to try all the junta members. That means that the highest military in the country, who were the minds behind all the horrors that had happened in my country. But then the military at that time were very, very powerful still yet, and they started new movements against the government. So the Congress, the Parliament, passed two laws. One that was to say, well, we are going to put a full stop, and we are not going to admit new trials, new prosecutions. We'll stop with the ones we have. And then afterwards, as the military thought that this was not enough, they wanted more, they had to sanction a law in Congress too, in Parliament, to say that, well, under a certain level in the military, they were all under orders. So that was the due obedience law, and so they were just accepted from prosecution because there was the responsible persons were the chiefs, the officers, the higher ranking officers. So this went on until, we have another thing. We have the pardons by decree of some of the of the military who had been already tried and sentenced, and when sentenced to life, they were pardoned by President Menem by decree. It was a faculty, something that the Constitution said the president has the possibility to do, to pardon some persons. And, well, that was the situation until 2003. 2003, with the new government, the new president, the idea of repealing the laws, the due obedience and full stop laws, was taken by the parliament, and they say, okay, we just were forced to pass this law. We were just under duress, and this is invalid. We are going to nullify these laws. But then it's all the rule of law says that you can derogate a law, but you can nullify it backwards, let's say. So there was a problem, and they started to be some trials, and they went to the Supreme Court with some of the trials, and there was a decision in June 2005 that the court said that those two laws were unconstitutional because the Constitution has incorporated all the treaties and conventions on human rights, and one of the conventions says that you can't apply the statute of limitations, or you can't pardon, or you can't anything to warrant impunity to crimes against humanity. And so, if the tribunals, the courts, were saying that those were crimes against humanity, then we should go forward with the trials. And that's what is happening. This moment, just today or yesterday's night, I had the news that one of the person who was on trial because he was just helping to torture prisoners in some of the clandestine detention centers. There was a priest of the Catholic Church was just sentenced to life, and I'm very happy that had happened. Yeah, and I think this is the way to do it, because we are doing the trials with the proper judges, the civil judges, not military judges, the civil judges nominated, appointed, as the rule of law said they should be appointed. They are not a person who was selected just to do this. No, they're common, simple, normal judges that are doing their work, and they are doing a very hard work, and they're working very, very well and very good. And so this is not the first sentence of one of the military or people related to the military in my country. There's already been 2 or 3 after the Supreme Court just repealed this 2 laws telling that it was unconstitutional. And there are a lot of them coming. It would take a long time because there are a lot of people there. And the people in general, all the victims, all the families of the victims are not eager to let them go by. So I think we have trials for a lot of time, but the thing is that all the organizations that have to do with human rights around the world, and I think, for instance, one of the visit of Amnesty or Human Rights Watch or whatever, or the Commission of Human Rights, the American Commission of Human Rights, kept the country in touch with the world and kept all the person who could oppose the dictatorship or to try to bring back the rule of law to our country, just supported by all these organizations. Then it's much more, I won't say easy, but still you feel like you're not alone, and you can do a lot more if you have people supporting you. And that's the great thing about all these organizations. Thank you.
You've answered the last question that it was through it. You have answered it because you explained that it was through the medium of your human rights treaties that you were able to undo the prior law.
Yeah.
But I had just one follow-up question. The approach is obviously quite different from the South African experience, where it was decided to set up a Truth and Reconciliation Commission. The people came forward and confessed to their crimes. They would not be punished. Has there been anything comparable in Argentina?
While those periods that we weren't able to have the trials because those laws were enforced in Argentina, then there were some judges or some courts in the provinces that were making what they called the truth trials. It was not the Truth Commission, it was the truth trials. It was like a moot trial, but that people could come and say, but never the perpetrators had come before one of these commissions or trials. Never. It's always the victims, the witnesses, the families, the survivors, but never the perpetrator. Well, if it's a trial, a formal trial, you have to come. You're a defendant. I'm sorry, you have to come, and you have to be in prison. That's it.
Can you give us an idea of the length of the sentences? The
length? Well, no, it depends. There would be some of them that were related to some part of the army or the navy that are very, very big. That would be very difficult because you have a lot of defendants that would take a lot of time. And then on the other hand, there's a lot of problems 30 years after or 28 or 27 to take the evidence, to have the evidence, to find the witnesses or the victims. Some of them are dead, others have moved, the others are refugees in other countries. You can take them back to go as on the witness stand. It's difficult. I don't know how long we will take, but we'll do it. I hope.
Thanks so much, Justice Argibay. And for Judge Cerda, I have been asked to pose these questions. First, if you can describe to us, in short, the prosecutions that have been instituted in Chile against General Pinochet and members of his family. That's the first question. And the second is, would those prosecutions have occurred in your country had there not been the assertions of universal jurisdiction, first by the magistrate in Spain and then in the UK?
Si no lo hubiera hecho Garzón, si se hubiera hecho en el país.
Exacto, que si Garzón no hubiera invocado los principios de jurisdicción universal en caso de derechos humanos.
Unfortunately, I cannot to respond directly in English, so I will do so in Spanish, and Patricia Cepeda will translate that. Causas seguidas respecto de Pinochet y su familia. Sí, a partir de los años en los cuales todavía gobernaba Pinochet, estamos hablando de el último lustro de los años 80, hubo acciones dirigidas en su contra como una manera de saber el destino de detenidos desaparecidos principalmente y de sancionar a quienes habrían torturado según se denunciaba.
About the cases against the General Pinochet, starting in the 80s when he was still in power, there were some cases brought against him, but mainly to see what had happened to the detained or disappeared.
Pero el conjunto de antecedentes que toma mayormente fuerza desde el punto de vista procesal respecto de Augusto Pinochet Ugarte, que en paz descanse, digamos, tiene lugar con motivo de su detención en Londres a raíz de una orden de aprehensión que, como ustedes conocen, se había emitido en España por la fiscalía de la que formaba parte el juez Baltasar Garzón.
But from a procedural point of view, things really started to happen against General Pinochet, may he rest in peace, with the arrest warrant by Judge Garzón made from his Spanish base, which then led to the whole chain of events.
¿Por qué el conjunto de antecedentes toma fuerza a partir de entonces? Porque con el regreso de Pinochet al país, todos los sectores, incluso aquellos sectores civiles que en su momento lo habían apoyado, comparten la idea que debe ser en Chile donde se lo someta al due process of law.
Why did this effect of his arrest ordered by Judge Garzón in London led to this whole chain of events? Because it gives his return to Chile is what leads all various sectors of society, even those that had supported him, to realize and to become conscious that he must be tried in Chile, where he would be subjected to the due process of law and not abroad.
Se inicia una serie de investigaciones por el juez Juan Guzmán Tapia, que también ustedes han escuchado, y que son en número de centenares y que tienen relación con las denominadas violaciones a los derechos humanos.
Hundreds of cases were investigated by Judge Guzmán Tapia, whom you have also heard from, and that there are hundreds of them. They mostly have to do with the violations of human rights that occurred during the dictatorship.
Se hace muy difícil la eficacia procesal cuando un juez tiene tanto que investigar.
It's very hard to be efficient in hearing all these cases because one judge has to investigate all of them.
Entonces, el año 2002 se toma la decisión de dividir estas investigaciones y distribuirlas en un número de jueces elegidos por la excelentísima Corte Suprema de Chile.
In 2002, the decision was made to take these hundreds of cases and divide them among a select group of judges chosen by the Supreme Court of Chile to hear them.
La mayoría de estas investigaciones, de estos cases, están abiertas porque se someten al antiguo procedimiento penal vigente en Chile, un sistema inquisitivo, y han ido concluyendo muchas de ellas en condenas a quienes tuvieron a su cargo, según se ha comprobado en esas causas, tales violaciones a los derechos humanos.
Most of these cases are still open, but some of them have already been finished and they have resulted in sentences to people proven to have violated human rights during the period.
No hay limitaciones de ningún orden en estos procesos, de tal manera que se puede decir que los jueces que los tienen a su cargo son totalmente libres y es posible en plenitud cumplir las exigencias del due process of law.
There aren't any limitations in how long these cases can take for the judges to be able to fulfill due process in hearing all of them.
Termino respondiendo la pregunta de Justice Ginsburg en el sentido que paralelamente y a raíz de descubrimientos efectuados por el Senado de este país, de los Estados Unidos de Norteamérica, se inició una investigación en 2004 respecto de posibles desfalcos, mal uso de dineros públicos, lo que llamamos malversación de caudales públicos, tal vez, respecto de Augusto Pinochet Ugarte y sus cercanos, entre los cuales parientes y colaboradores.
In 2002, because of a U.S. Senate investigation, it was possible for us to bring cases against the Pinochet family, close circle of collaborators and friends, on the possible misuse of public funds.
Esa investigación está vigente, activa, abierta.
That case is open.
Again, we see the effect of opinion outside the country in promoting judges inside and giving them courage to proceed. And you mentioned specifically Garzón in Spain, the UK, and most recently the United States. So I thank you.
You are welcome.
And now I'd like to ask Mónica Feria this question. It has been reported that in reaction to the ruling that you won for your clients from the Inter-American Human Rights Court in the prison massacre case, there have been some political actors in Peru advocating that the court's ruling should be defied, should not be observed, and even that Peru should withdraw from the Inter-American Convention on Human Rights. Can you tell us what those actions have been and the prospects for their success?
Thank you for the question, Justice Ginsburg. Yes, the Castro prison case was adjudicated by the Inter-American Court, who handed judgment in November 2006, 25th. The judgment made a very, very big impact in Peru. It was in the news for a month, perhaps. And the feeling in Peru was uneasy because for almost over 13 years, the version of the facts in connection to the prison massacre was that it was not a massacre, that what took place there was an attempt to transfer women to another prison, and that there was a riot. And that was just perhaps a little bit of an excess of use of force that certainly was not a crime, and nobody was prosecuted for that. But that in any event, it was not a massacre. And it did not, the society did not acknowledge either the treatment that survivors were given, in particular all the different practices of torture. It was never really acknowledged also the infliction of violence against women, including to women that were pregnant during the time, the use of a number of illegal weapons and practices on people that were incarcerated and had no means of defense in their condition. So it did broke a lot of, perhaps it was difficult for Peru to accept that an Inter-American Court of Human Rights had asserted the facts differently from what had been the official version. I believe that there is still a process to digest the truth. Truth is something that can be denied, but eventually I firmly believe that societies, in order to move forward, have to accept facts. What Peru did immediately as a consequence of all these general upheaval surrounding the decision in Peru was to say or suggest that perhaps the Inter-American Court had gone too far. In fact, Peru participated throughout the 10 years of litigation actively in the proceedings. It had representation throughout the commission stage and throughout the court stage of the case. It participated in the hearing, and during the hearing took place in El Salvador, and at that hearing, the administration of Toledo acknowledged that it has taken place a massacre in that prison. Peru itself acknowledged partially what had taken place towards the end of the litigation. We managed to bring experts and prove the facts in a way that in the judgment this could be clearly reflected and the law could be also stated in a very clear manner for the future and for other jurisdictions. So Peru has now, with the change of government, with Alan Garcia, who came to power, the administration changed maybe its views about the standing that the state had taken with this particular case. But that is not an issue of international law. States are accountable as states, not as governments. Its latest position has been that they wanted an interpretation of the judgment. The court made it clear that the court cannot change a judgment. There has to be specific legal issues that may have obscurity. Those were the only basis for asking an interpretation of a judgment. In my opinion, that basis has not been satisfied in this case. The court is going to decide on this issue towards the end of this year. But something to point out is that Peru has not challenged the facts. Maybe the media has reported so, but in the actual brief that Peru presented, Peru has asserted that it's bound to comply with the judgment, that is bound to respect inter-American system. It has clearly stated that it believes in the work of the court. So perhaps the media has distorted as well what Peru as a state stands right now in the actual proceedings. So I hope that towards the end of the year we will have a decision by the court and the position will be clarified. The court has already said that interpretation of the judgment does not stop the legal effects of the judgment. One of the issues was the prosecution of Fujimori, and the court was clear to request from Peru that Peru does all the judicial and the diplomatic, takes all the measures in both aspects to ensure that all the individuals who were participating with different degrees of responsibility in these atrocities are prosecuted. And we had a recent exchange of communications with the court and with Peru just days before the extradition. I did file a paper where I suggested to the court I was deeply concerned about the lack of action on the part of Peru to present the Castro case as one of the most serious cases currently pending against Fujimori in Peru, as one of the extradition cases in Chile. And within 3 days, Peru issued a formal legal resolution signed by President Alan Garcia, who approved to send this new cuadernillo de extradición, this new file, to Chile so that Peru can comply with the judgment of the court. So that's what I can comment so far. Thank you.
Has there been any compensation, in fact, paid to the victims up to this time?
No, Peru has a term to comply with those aspects of the decision. The court established that the period is 1 year and 8 months. This is a very, very big case. We're talking about considerable amount of individuals. So there are many aspects that has to be implemented before being able to comply with the compensation aspects. And so it's still early times to make assertions as to what is going to happen in that respect, but we are going towards a year already since the decision was issued. So Peru still has another 8 months to work on the implementation of that measure.
Thank you. Now I'm turning to questions that I've received from the audience. And one touches on an issue that you've already mentioned, and that is the difficulty of resurrecting evidence 20, 25, 30 years after the event. One particular concern when you're dealing with government offices is what we in the United States call state secrets. That is, the government, if an officer is being sued, the government's answer may be, this person can't defend himself or herself because the defense would reveal classified information, state secrets. If the information came out, it would endanger the lives of others. Do you have in your systems something comparable to the notion of state secrets that cannot be revealed and introduced into evidence?
We do. I'll take the floor first. We do, but this government has already sent the resolutions to the defense minister that there are a lot of things that were classified as military or state secrets that were not. So they were lifting this secret just to provide the court with the documents related to this military dictatorship, because they say this is not endangering the state at all. It's only to protect and to be accomplices to these men, perpetrators of these crimes against humanity. So we'll lift the secret of these documents, and that's the government who said through the Minister of Defense, but it was the government implied in all these terms to facilitate prosecution and justice in the end.
Did the judges themselves inspect the documents to determine whether they were properly labeled state secret?
I don't know yet, but they are starting. At least they have started to do it. But I don't know if in every case should need to review the documents or whatever. They are at the disposition of the courts. Let's see what is going to happen. I don't know.
Do we have responses, Judge Cerda?
Okay. Sí, desde mi punto de vista, y creo que en esto represento el sentir de una cierta cultura jurídica nacional, la teoría del secreto de Estado pone en jaque a la justicia democrática o a la justicia en una democracia. ¿Por qué?
I think, from my point of view, and I think I represent the feeling of our national juridical culture, that the state secrets legislation puts justice in peril in a democracy.
Porque la justicia en una democracia propia de un Estado de Derecho está sobre todo para defender a las minorías.
Because justice that is appropriate to a democracy and life under the rule of law, justice should be made to defend the rights of minorities.
De manera que nadie, cualquiera sea la clase de minoría de que se esté hablando, sienta el desamparo de sus derechos esenciales frente a los actos del Estado.
No one should feel unprotected, that their basic essential rights are unprotected against the state.
Si no es capaz el Poder Judicial de garantizar la defensa de los derechos esenciales cuando se acusa al Estado de desconocerlos o violarlos, entonces se acarrea la inseguridad en el más propio de sus sentidos.
I think if the judicial branch is not able to guarantee the defense of the essential rights of the people versus the state, then the whole democracy is in peril.
Es fácil para el Estado amparar sus actos bajo el pretexto del secreto de Estado.
It's easy for the state to take cover for their actions under the state secrets banner.
Actualmente la Constitución chilena ha sido modificada. Digo actualmente en un periodo, no sé si alcanzó a cumplirse ya un año, algo así. Y se estableció la publicidad de todas las actuaciones de los órganos del Estado.
Right now, and I'm talking about a year ago, the Chilean Constitution was modified, and one of those modifications was the public nature of all state actions.
Es este un triunfo más de la democracia
This is another triumph for democracy.
que permite a los jueces siempre hurgar en las causas y motivos de cualquier acto, incluso del Estado.
But that it allows the judges to be able to get into any kind of causes or evidence of the state in actions against the
Esto
state.
favorece la transparencia,
This is in favor of transparency,
contribuye a evitar la corrupción
contributes in the avoidance of corruption in government,
y sobre todo hace que el pueblo, la gente, sienta que a través de los tribunales puede enfrentarse en términos de igualdad al Estado.
and it also contributes above all to people feeling that when they have to go up in a court against the state, that they can be in equal footing.
Subsiste, y con esto termino, Justice
This
Ginsburg,
will be my last point.
hay en la judicatura militar una norma especial de resguardo para actos que tienen que ver, que están relacionados, no sé usar la terminología exacta porque no me acuerdo en qué término está redactada la disposición, pero tiene que ver, digo, con actos de soberanía. Allí se establece cierta reserva.
There's a certain reserve in the military system having to do with acts related to sovereignty.
Estamos viviendo en estos momentos una determinación del límite, de border, en esta temática con la nueva disposición constitucional.
We are right now currently living through some kind of negotiation about what the limits are of this protection in the military courts for acts committed in the name of sovereignty.
Pero puedo decir que, puesto que me corresponde dirigir una investigación en que en cierto modo están concernidos dineros que pudo haberse obtenido en actos de obtención de armas para el país,
Because right now I'm investigating a case involving monies having to do with the purchase of arms for the country.
potential form.
Potential.
Yeah,
Potential.
that's
for the
yeah,
country,
yeah,
yes,
yeah.
yes.
I nothing say about, yeah, without
Alleged,
conclusions. yeah?
Alleged,
So,
yes.
so in this level, I have been a total collaboration from the state.
Alleged.
I think some of the students might be interested in understanding that your role, you are a judge, but you are an examining magistrate. That is, you are not listening to a case to determine the guilt or innocence of the defendant, but you are taking the place of what a grand jury would do in the United States to determine whether there is enough evidence to put this person on trial. And that's a kind of a judge that we do not have in the United States. There's a question, let me read it to you. It says, taking account of the adverse effects on justice and the victims of not calling people to account for crimes against humanity, for government abuses. There's also a concern about giving the government an incentive to step down, to have the bad actors leave. And do you see a role for impunity laws or promises of amnesty? That is, if you step down and go off to the Riviera and never return again, you won't be prosecuted.
Esa alternativa yo creo que está descartada en Chile.
I think we will not use that alternative in Chile.
Nosotros no tenemos el sistema de un posible arreglo entre un prosecutor fiscal y un defensor.
No. We don't have a kind of plea system where we would make a deal with a defendant.
Tampoco existe en Chile el sistema de una suerte de premio o beneficio o privilegio por la colaboración en el proceso.
We also do not have the kind of prize or benefit of somebody who will collaborate with the process, a cooperating individual.
Entonces, cualquiera sea la actitud que asuma un imputado, inculpado o acusado, igualmente puede ser llevado a juicio de condena o absolución, un debido proceso de derecho.
Whatever attitude the accused takes or his response, he can still be taken to a trial which will end either in him being being imposed a sentence or him being absolved.
Y agradezco mucho la pregunta porque, claro, en este trabajo, Justice Ginsburg y público en general, uno conoce al ser humano que no obstante imputado de graves conductas es tan rico como todo ser humano. Y uno debe tener conciencia de aquello, que no está contra alguien, sino que está en favor de establecer con ese alguien, ojalá, la verdad sobre la cual y únicamente sobre la cual puede hacerse justicia con miras a la paz social.
I'm grateful for your question, Justice Ginsburg. I think in our work we are very familiar with the human condition, and even people who come before us accused and how precious each person is. We are not having a case against someone. We're trying to establish the truth of something and how that someone was involved. And this is the only way that we can do justice, so it brings about a social peace.
Y entonces no es infrecuente encontrarse con un imputado arrepentido, que él mismo ha cambiado su vida, no obstante lo cual, responsable que sea de un acto así establecido en el debido proceso, condenado es.
It's not infrequent that we have people come before us who maybe have changed their lives, who have repented for their deeds, but no matter how, if they are responsible and would be able to establish that they were responsible for violations and give them their due process, they will be imposed a sentence, found guilty and imposed a sentence.
Y termino, Justice Ginsburg, perdone la extensión.
I'm sorry I went on.
Ese también es un chileno, es un latinoamericano, es un ciudadano del mundo. También lo era Augusto Pinochet Ugarte. Y cuando dije que en paz descanse, lo digo con toda sinceridad. Lo interrogué Estuve fuera del proceso tomando té con él en su casa y tratando de descubrirnos ambos. Él como el imputado, culpable y bien yo lo sabía de conductas que no deben ser aceptadas no solo por el derecho, sino por la cultura en general, por la historia. Y yo, como aquel que tal vez iba a pasar a la historia, como quien había de juzgarlo. Qué pequeñez de ambos y qué grandeza de ambos. ¿Por qué? Porque en razón de lo que exige justamente esa verdad y esa justicia, dos personas compartían un momento de sus vidas.
Because even Augusto Pinochet Ugarte, and when I said may he rest in peace, I did mean that honestly. He was a Chilean, he was a human being, he was a citizen of the world. Even though I had interrogated him, I also sat down with him for tea. He was the accused, guilty of acts that are unacceptable to humanity, history, and our culture. But in order to judge him, I really needed to find where the truth lied, and this led to a better understanding of what had gone on.
Thank you, Judge Cerda. Now we have a question that's specifically directed to Mónica Feria, which is, could you tell us about the early experiences in your life that led to your resolve to become a lawyer?
Thank you for the question. I would say that I knew I wanted to be a lawyer when I became 12. Yes. Why? I grew up in the midst of a dictatorship in my country. We had a dictatorship, a military dictatorship for some time. And I realized as a little girl that we didn't have really liberties. And I witnessed when I was coming back from school some demonstrations. There was a very long strike in 1977 of workers, of teachers, and it was a very difficult times for Peru. And I felt that I wanted to do something about justice. I didn't like the feeling of injustice, even in my little world at school. And it appeared that I was a good advocate of some of my colleagues in front of the teachers. Somehow convinced the teachers that maybe you should give a hearing to that person. And I thought that I could do that. And my resolve then came from when I was 12. It never occurred to me that as a woman in Peru, from an Andean kind of background, that would be a challenge. It never occurred to me it would be a challenge to enter to university. I just knew I wanted to do that in my life, and I'm quite glad I decided that.
Thank you. And now I have a question directed to Justice Argibay, and I'm curious to hear your answer because it's a question I've been often asked. It is, did the women judges on the International Criminal Tribunal for the former Yugoslavia contribute to the court's jurisprudence in a way that differed from the contributions of the male judges? And if so, what were those contributions? Could you give us some examples?
Well, thank you, Justice Ginsburg. The ICTY is an experience very dear to my heart, so I like very much talking about that. And I can say that sometimes perhaps it's not so easy to see it in the jurisprudence of the tribunal, but that the contribution of the women judges is very important. Everybody has recognized that. And I can tell you that in the trials, at the hearings, it is very noticeable that sometimes the women judges are more attentive to the needs of the witnesses or the persons, especially the victims who are taking the stand and telling the presiding judge sometimes that usually it's a man, please make a break. And when you make a break, it's what's happening. You need to give the witness a little rest because he's too emotional, that sort of things. And with the translator, the interpreters, because they were from the former Yugoslavia, most of them, they were speaking the two languages, of course, the languages of the defendants and the witnesses, and the languages of the tribunal. So it's their history, their place, their families, their war. In 20 minutes, they could break down 20 times, listening to the people telling their stories. So they are repeating their stories as translators. So they break down easily. I know they're heavy smokers. I'm a smoker, but they are heavy smokers. So I usually put a note to my presiding judge. It was a Chinese judge. He was very gentle and very nice, but he never realized that. And I said, break. And so we went out, and he said, what's happening? Are you feeling ill? No, I'm not feeling ill. Having to listen to the translators, they were crying. So we need to break, to give them time to have a cigarette, a coffee, whatever, and recover. They're telling us their story. That's heart-wrenching, I can tell you. And that for the women judges, and for a lot of male judges also, sometimes you would like to hold the hand of the victim and say, I can understand you. And you know that in the bench, you have to have a straight face because the lawyers for the defense are looking at the judges just to see any sign that you're sympathizing with the victim or with the witness or with the prosecutor or whatever. So they are looking at you every time, so you have to have this straight face. But then when you get to chambers and you start discussing what you've been hearing and listening to and seeing, because you're seeing a lot, corporal language, is very important. That makes a difference too. I remember talking with my first presiding judge, who was a German and very good too. And we have a case of one of the camp of concentrations in the northern part of Bosnia that were very similar to some of the German concentration camps in the Second World War. And there was a woman who was telling how she was raped by the chief of the person on charge of that concentration camp. And the prosecutors was presenting the case, and the defendant said, well, it's impossible, she's telling lies because she's telling that one day it had happened, this thing had happened, and the next day the same thing had happened. It's impossible that she got so many clothes or so many things or something. And I remember talking with Schomburg, that was my presiding judge, said, remember, she was raped every night since she was at the camp. But she remembers especially the first night. So for her, every other night was a sequence, a repetition, the same thing as the first day, exactly the same. Of course, she was not menaced with a knife all the nights, but perhaps all the first 3 or 4 or 5, probably she was menaced with a knife. So what happened is the 20th night, she was not, I'm going to say that was not rape at the time. And he was in agreement with me, but it takes a woman to talk about that. Because they didn't like to talk about that. So it was something that to accept that a woman could live something repeatedly and the same thing, it occurs to her in the first time and the 20th time. And so she unifies the idea and can tell in one night whatever has happened in 20 nights. But that doesn't mean that she's lying. And Shamu understood that, and he had the sense of that. But it takes me to come and say, well, we discussed this. We're going to discuss this because the defendant is saying she is lying. So women judges make a difference. We can talk about a lot of things that male judges don't talk about if there's not a woman judge there. That's not easy for them to talk about women issues, crimes against women. It's not easy for them to talk about. But if there's a woman judge, then they can talk about. And then things go easily and much better, I think. Thank you.
This panel has been of such large interest, but it is getting past the witching hour. So I would just like to ask each of you if you have a piece of advice about becoming an effective professional, effective lawyer, that you would like to impart to the students who are here.
I'd like to say something. I think the best thing in any profession, any state of life, whatever, is to act honestly, on conviction, and with courage. And that's all. Thank you.
Piece of advice, I would say persistence is very important. It may take time to prepare your case, to plead your case, to go somewhere with a case, but if you persist and you have that commitment to make things happen, you will certainly go somewhere. And I think that will make a difference.
Judge Cerda, you have the last word.
Oh. Qué desafío.
What a challenge.
Confianza en que el caso habla por sí solo si uno a él se acerca con total humildad.
To have the trust that the case will speak for itself if you approach it with total humility.
Thank you, Justice Ginsburg, Dean Alenikoff, Justice Argibay, Judge Cerda, and Ms. Feria. Ladies and gentlemen, thank you for being with us here today. One last round of applause for this year's Justice Prize recipients. Thank you.